So what happens if you're going through probate, but you can't find the original will? And what we mean by original will is the actual wet ink signed will that the decedent executed during their lifetime. So not just a photocopy or an image or a draft, but the real deal. If that can't be located, there's a presumption in Florida law that the will was revoked. So that has to be overcome if the parties want to try to prove and admit something other than the original will. So if you're in a situation where you at least have a photocopy of that will and there's someone who can testify that it's a true and correct copy and that the decedent, to their knowledge, did not intend to revoke that will along the way, it may be something that could be admitted in court. If you don't have a copy of that, then the two disinterested witnesses would have to appear and provide testimony that satisfied the judge. So it's definitely a lesson to make sure that your important documents are accessible and available when the time comes. The last thing you want is for there to be a fight over those who are proponents of the will versus those who would take as intestate heirs if the will were thrown out. If you have a question about admitting a will or anything having to do to probate, let us know and we'll see if we can help.